Dr. Mulligan. Every single time I go into this conversation, I get confused. So forgive me, because it's such a it is an endless range of different scenarios, because each surrogacy scenario is completely different. Whether that's same sex, whether that's the genetic link or no genetic link, and all of this. And I suppose a question, you mentioned that the surrogate would have those legal rights, and I just want to follow up on what the chair was asking. Is that just for that short time, or is that for an indefinite, that they would have that legal right, even though the intending parents are, the guardians, they are the parents, that there would be that tripartite agreement in a way, that there would be the parental rights of the intending parents, and the surrogate would have the legal right indefinitely. And I suppose for me, if that surrogate had legal right indefinitely, what sort of consequences has that then on a long term, whether that be for inheritance, the rights of a child to their inheritance, if there was no other children in that surrogate mother's life. And it just, again, it opens up a whole pile of other questions for me to and obviously the right to identity and the knowledge of that surrogate is very, very important, and that is something. But the legal right for the child onto that mother, and vice versa. I just wanted to ask about that. And just on a follow-up to previous points as well, as the pre-birth orders, and I really understand what you're saying about that I suppose how it'll end, but is there a way, like, of legal continuance that pre-birth order would set in a framework and a definite, and there's always a veto after, that there would be a period of time that, yes, the pre-birth order is there for everyone's protection, because we must protect everybody, and to allow everybody in that, for the want of a better word, in that contract, because it is a contract, no matter whether it's a legal contract, it's some sort of a contract, and to have that follow through. That it is pre-birth with a continuance into post-birth, to ensure, as you were saying, that the intending parents are, adequate, or that they intend to do everything proper, for the want of a better legal description. But I probably have more confusing questions in my head, but I'm trying to listen. So thank you very much, Doctor.
Thanks for letting me go with those. To be clear, I'm not saying the surrogate should have indefinite rights to the child. So actually a difficulty at the moment is that in Irish law, the surrogate does have indefinite rights forever. So the birth mother is the mother forever. So that, for example, in terms of getting a passport, technically speaking, you need that child, the surrogate's consent to the passport until the child reaches 18. And the courts will dispense with that consent, but technically the presumption is she's the mother forever. So that's a huge difficulty. So you certainly don't want that situation. It's not good for a child as well to have either uncertainty about this or a fractious relationship between different people, right? Nobody wants that. So I'm certainly not saying that. And it is a huge problem in Irish law at the moment. That, you have surrogates abroad who remain, as a matter of Irish law, the child's mother forever. They don't want to be the child's mother forever, so certainly not. I certainly wouldn't advocate that. The pre-birth orders, I think you raise a really good point. So in terms of the kind of two-stage process idea, I think under the legislation at the moment, what's proposed is a two-stage process, essentially, where you have essentially a legal process during the pregnancy to sort of sort out all these things, and then a sort of confirmatory process later on. To switch parenthood over, right? Then the final parental order. And actually, I totally agree with that. So I think I'm actually very much on the same page. My difficulty when I say a difficulty with pre-birth orders is that being the final order. And as a matter of the law in some US states, the final order is the pre-birth order. That's it. The parents of the intended parents could walk into the hospital, snatch the child from the surrogate immediately if they wanted to. that doesn't happen. That's not something that happens commonly, but that is the legal reality. The surrogate would have no right to complain about that. She would have to go to court to actually complain about that. Okay, so that's what a strict pre-birth order regime looks like in practice. Because in those US states, the definition of parenthood is very contractually oriented, and there are pre-birth orders that would allow for that. So that's the situation that I have a difficulty with. I have no problem with there being a court process during pregnancy, whether it could be a regulatory process at the regulator, it could be a court process, it could simply be a contract, where everybody sets out their legal position. But I think the final order should happen subsequent to the birth, which is the position under the legislation. And I would say, it's really important to see in terms of the pre-birth, post-birth question. I think everyone seems to agree that with international surrogacy, you're always going to have a post-birth order anyway, because we're not in a world where we can just directly recognise orders in other countries. And I think, as I understand it, that's one of the reasons that I think that has been noted, that you would have a sort of unfairness between international and domestic surrogacy. So maybe one reason to have a double stage process in both makes sense.
Another question, and I suppose it's regarding, and maybe by doing this, you're entering into a tiered parentship here, again, a different sort of tiered or levels, but for a genetic link, and for me, if there's that clear genetic link, then it's very clear, and I don't want to pit a genetic mother against a non-genetic mother, but if there is that genetic link, is there cases in other countries that genetic link is more matter of fact, and that surrogate link is very much clear, and that the surrogate is recorded, it's very obvious that scenario happened, but the genetic link, genetics have to count for something, so they do for a man, very clearly they do for a man, and we already have that difference, and is there a case that the genetic link for mother should be equal to a genetic link for father?
Well, this is the difficulty. So, yeah. I mean, we are talking about surrogacy, we're talking about legalising surrogacy. Yeah. So we are all acknowledging that it is possible to separate motherhood from gestation, right? That's why we're here. We're having this conversation. We're saying that the surrogate is not going to be the parent. So that's clear. What's difficult about the status of a mother, who gives birth ordinarily, is that there is a genetic link and a gestational link, and it's just different to fatherhood. Which is not to say that this law should take the position that the gestator is always a parent, not necessarily. But the reality is that if you have just in the rare cases where gestational surrogates change their mind, they're not people who are strangers to the child. They're people who gestated the child, and that is something, And it's not that I don't think this committee nor anyone can say for definite what that is, what that means. But I think you have to accommodate, this difficult scenario where in the rare cases where the surrogate changed their mind. But I don't think you don't decide it for all time. This law should not say, that the genetic parents can't get that child if there is a dispute. You could make a rule whereby the genetic parents will always be entitled to be the parents no matter what. You could, but I mean, I think that's slightly outside the purview of this committee's work anyway, because that's really a domestic surrogacy question.
Yeah. And sorry, can I just ask another question? Yes, very quickly. In this legislation, and what we're talking about here is very clear, birth mother and mother. In the information and tracing bill that we're putting through at the minute, we've taken out that definition of birth mother, which has brought up a lot of questions. But will that have an effect then in Irish law? We're after taking out in one scenario, taking out the term birth mother and classified all mothers as mothers, whether they're the birth mother or not. Will that have a legal effect on this type of scenario? Yeah,
that's a really good question. I don't know I haven't looked at the current draft of that bill. I was familiar with earlier drafts, but possibly. And unintended consequences is a really important question here. Yeah. So, for example, you all know that the intended mother can be appointed a guardian. That's an accident of Irish family law. That's not meant to be. That was never intended to be used for surrogacy, as far as I know. There's no public record of that. So, possibly is the answer, that, you know, you do have to look at all that terminology. You know, you might avoid using the word mother altogether and use the word surrogate.
Yeah.
I don't think you have to describe the surrogate as a mother. She probably doesn't want to be described as a mother. But, you know, certainly in terms of drafting, you'd have to be careful about language like that.
Thank you. Thanks.
Yeah.